Duke Energy Florida LLC versus Clark.
Good morning. May it please the court. I'm Daniel Nordby from Schutz & Bowen, and along with my colleague Alyssa Corey, I represent Duke Energy Florida in this proceeding. I'd like to reserve 5 minutes for rebuttal. In 2009, Duke Energy placed a combined cycle power plant into commercial service in Bartow, Florida. This case involves Duke's petition to recover replacement power costs related to an unplanned outage that occurred 8 years later in February of 2017. Under the legal standard acknowledged by all parties, Duke Energy is entitled to recover its costs if it was prudent in its actions and decisions leading up to and in restoring the unit to service after the February 2017 outage. Unless the court would prefer otherwise, I'd like to address two principal reasons why the Public Service Commission's final order should be reversed. First, the administrative law judge and the PSC erred in concluding that Duke Energy was not prudent in its actions regarding the February 2017 forced outage. The legal concept of prudence is a term of art in public utility law that requires actions consistent with what a reasonable utility manager would have done in light of the conditions and circumstances that were known or that should have been known at the time the decision was made. This court has said that imprudence cannot be found based on the 2020 vision of hindsight. Here, the undisputed evidence was that Duke Energy was operating the Bartow plant prudently at the time of the February 2017 forced outage, and in fact for a period of several years preceding the 2017 forced outage.
Counsel, can we just focus on testimony of Richard Pollich, which is in the record, right? I mean, you'd agree that that's there. Help me understand how you get around that being a basis that the ALJ might have prudently or judiciously relied upon, permissibly relied upon, even if you don't agree with it.
I'd be glad to. So Mr. Pollich's testimony, which was the only testimony that was offered on behalf of the interveners in this case, represented a few important things. First, Mr. Pollich agreed that Duke Energy had acted prudently not only during period 5 at the time of the forced outage, but in periods 2, 3, and 4 leading up to the forced outage. The only dispute, the only material factual dispute at the administrative hearing involved Duke's actions 5 to 8 years before the outage during what we've called period 1. Mr. Pollich's testimony was that Duke Energy had acted imprudently during period 1 by operating the plant above a certain nameplate capacity for its generator. At the administrative hearing, Duke Energy raised two arguments in response to that. First, that Duke actually had acted prudently in period 1, that the nameplate capacity was not an operating condition. But then in the alternative, that any imprudence in period 1 did not cause the period 5 outage for which Duke Energy sought to recover.
And just so we're on the same page, the hearing officer found that Duke did act imprudently in operating the unit above the rated capacity of 420 megawatts, correct?
That's correct, Justice Lawson.
You didn't contest that?
We contested that at the administrative hearing. Right. We filed exceptions to that at the Public Service Commission. We are not advancing that argument on appeal. We feel that it was error, but not reversible error. And it's not necessary to reverse here because of our alternative.
So would you agree that if that imprudent action factually caused the damage to the components in 2017 and the subsequent derating, that would be sufficient to deny the petition for recovery of the costs?
I would. If the period 1 imprudence caused the forced outage in period 5, that would be a basis. But there's no competent substantial evidence.
About the expert testimony that it was the most probable culprit, that the actions before 2012 were the most probable culprit in the problems that occurred after that, and the replacement in 2012, the replacement in 2014, the two replacements in 2016, I think it was, and then the problem in 2017, that all of that is because of the vibration of the unit that resulted in a condition that caused that component to continue to wear out faster than it should have.
Well, Justice Lawson, and in fact, in response to Justice Curiel's question as well, Mr. Polish explicitly disclaimed any causal relationship between period 1 imprudence and the damage that occurred in period 5. And that's at page 3405 of the record.
And can I ask you, so it seems like this is, the whole case, it seems, turns on the ALJ's view that once the imprudence was established for period 1, that it became your burden to disprove the causation. Because the way I read the order, which, you know, isn't a thing of beauty by any means. I mean, paragraph 119 should be in a book for, you know, how not to write a paragraph in these things. But it you know, basically it seems like the reasoning of the order is we have found imprudence in period 1. No one knows really what the connection was between period 1 and what happened afterward is, but because of the imprudence, it became your burden to disprove the causation, and since you didn't do that, you lose. That's the way I read the order. So do you accept the premise that it became your burden to disprove causation?
Well, I agree that Duke Energy ultimately had the burden to prove prudence in the overall proceeding. I think we did that based on the evidence.
And it seems like you proved that you were prudent. It seems like what you proved was that your follow-up actions were prudent. I mean, I think that's kind of a fair, I mean, nobody challenged the prudence in periods 2 through 5. It seems like there's definitely competent substantial evidence to support the finding of imprudence for period 1, which you're not contesting now, even though you didn't start off conceding that, but now you are. So why isn't it right that it was still your burden to disprove the causation? I mean, and that's not a rhetorical question. I mean,
no. So I think that the evidence shows that we, to the extent we had that burden, we did prove it based on the evidence at the hearing. So there's kind of two conceivable ways to link the period 1 conclusions to the period 5 outage, neither of which occurred here. One of them, for example, would be if the blades that were damaged during period 1 remained installed and ultimately malfunctioned in period 5. That would link the period 1 imprudence to period 5. Another would be if something else happened in the turbine that was the result of period 1 imprudence that manifested in period 5. But there's no record evidence of that either. The uncontested testimony of Mr. Swartz at 3077 to 3079 of the record, and the testimony of Mr. Polish, the intervener's witness at 3401 of the record, said that there was no damage to any steam turbine component other than the L0 blades that were replaced at the beginning of period 5. So if the only evidence from both of the witnesses here was that the damage was exclusively to the blades, and they were new blades installed at the beginning of period 5, and there was nothing else in the record of any evidence of damage with the steam turbine, then there's simply no causal link.
What did cause the problem in period 5?
Well, I mean, we've referred in our brief to a couple of exhibits, Exhibit 82 and Exhibit 83, which contain some confidential information that I don't want to go into here, but the Mitsubishi root cause analysis identified some problems, but they weren't the problems that the Office of Public Counsel and the other interveners identified as causing the period 1 imprudence. Their theory as to period 1 was that it was operated above nameplate capacity. The record's undisputed that it was not operated above nameplate capacity in period 5, or indeed through periods 2, 3, or 4.
So I read Pollock's testimony as saying essentially that the cumulative wear on the unit from excessive vibrations during period 1 was the most probable reason for the need to replace the blades and the continued wear on the blades throughout periods 2 through 5. If that is correct, if he said that, wouldn't that be competent substantial evidence to support the hearing officer's finding to that effect?
If he said that, I would agree. I don't think he said that. I think his testimony about cumulative wear was directed exclusively at period 1. One of the disputes about period 1 was whether the blade damage occurred at times when Duke Energy was operating above nameplate capacity or below nameplate capacity. Mr. Polich's testimony on that point was that it doesn't matter because when it went above nameplate capacity and then went below, those effects were cumulative during period 1. But there's no basis.
But his testimony was during period 1, the wear was not just on the blades that were replaced, but it was on the unit itself.
He made a reference to general wear and tear on the unit, but he
Yes.
testified that he was unable to identify any damage. Again, this is at page 3401. Mr. Polich, the other side's witness, testified that he had seen no damage to any steam turbine component other than the L0 blades that could have explained the blade damage while operating within the established
So
parameters.
it's like we've experienced with our vehicles at times where they start making a noise and you take it in and take it in and take it in and they can't find the problem. I mean, that's the way I read his testimony is that they couldn't identify a specific problem, but the fact that that thing was spinning at a rate that it wasn't designed to spin and ramped down and ramped up over that period of time, period 1, wore the machine to a point that it couldn't operate at its rated capacity without wearing out those blades. I mean, that seems to be his testimony and seems to be what the hearing officer found.
Well, I agree that's what the hearing officer found. I disagree that that was his testimony or that there was evidence of that sort of an effect, a continuing effect beyond period 1 of the steam turbine component.
And let me just jump to your issue 2 really quickly. If that's what the hearing officer found in paragraph 119, then that really is a factual matter. So even though it was stated in a conclusion of law paragraph, the proper review of that would be for competent substantial evidence, correct?
A factual finding, even if contained in something denominated a conclusion of law, is reviewed as a factual finding. Many of the findings that are in the conclusions of law involve, I would say, mixed questions of fact and law. But paragraph 119 in particular appears to rest entirely on the idea that something imprudent happened in period 1 and then something else happened later. And that was really Mr. Polich's theory and the intervener's theory throughout this case.
Yeah,
that
paragraph 119 cannot be what this case is decided on. I mean, it seems, what I'm curious is it seems like a lot of the questions are going to, they're kind of assuming that the hearing officer made an affirmative finding of a connection between period 1 and what happened in period 5. And we're sort of looking through the record to see if there's support for that finding. The way I read this, though, there wasn't that finding. The ALJ did not affirmatively draw the link between period 1 and period 5. It basically just said, we don't know what the connection is, if any, and DEF didn't. So, I mean, would it be appropriate to send this back and ask for an actual finding on that? And it seems like the answer to that question has to depend apart on whether you had the burden to actually prove what the real cause was, or whether the whole point of this is to make the ALJ come up with what is the evidence show is the most likely explanation, and then sort of decide the case based on whatever that affirmative finding is.
So Justice Muniz, I think there's two ways to address it. One would be the way that you suggested, and that we requested in a form in our alternative argument that there be a remand for some reconsideration of the record under the standards here. The other would be just looking at the competent substantial evidence standard, because we would submit that there is simply no competent substantial evidence in the record, not even with Mr. Polich's testimony, that period 1 caused what happened in period 5. Mr. Polich's theory was that if it weren't for what happened in period 1, those blades would have still been in place, and there would have been no needs for periods 2, 3, and 4, and then ultimately period 5. That theory, though, was the very theory that the ALJ rejected as speculative in paragraph 119. So if that theory...
But it's an inference from the experience with the rest of the fleet, right? I mean, isn't that basically the support for that?
I disagree with that because I think that the record showed that this plant was different from some of the other plants and had some unique circumstances. I think some of that is addressed in the root cause analysis, that there were some factors specific to the Bartow plant. So what did Duke Energy do after the period 1 outage? Well, it did what a prudent utility manager would do. Talked to the manufacturer. It tried to identify through a root cause analysis, through trying different operating parameters, how to best operate this plant for the benefit of itself and its customers. And I think that's what led to the prudence determinations in periods 2, 3, 4, and 5, including the installation of the pressure plates in period 5, which was a direct result of responding to the forced outage in an attempt to get the plant operating in a limited capacity. It's exactly what a prudent utility company would do, and the PSC precedent states that utility companies can be prudent in relying on the advice of vendors who have superior expertise in this. If the manufacturer of the plant was giving advice to periods 2, 3, 4, and 5 on how best to configure this plant and operate this plant to produce at the best capacity, Duke Energy was reasonably entitled to rely on that advice and did so. And ultimately, throughout this period, past period 1 here, record is undisputed that Duke Energy acted prudently. I'd like to reserve the rest of my time for rebuttal.
Thank you. May it please the court, I am Catherine Cowdery, representing the Florida Public Service Commission. The legal landscape of this case does not include any disputed issues of law. It includes DEF arguing application of facts to points of law that are not in dispute and asking the court to re-weigh the evidence. The Commission used the proper standard of 12057 when considering DEF's exceptions and adopting the ALJ's recommended order. DEF's exceptions solely asked the Commission to reject or modify ALJ's legal conclusions, asserting that the ALJ misapplied the legal standard of prudence by applying hindsight, and that the conclusions were contrary to Commission policy. Those were its two arguments. The plain language of the final order shows that the Commission agreed with the ALJ's conclusions of law. Contrary to DEF's assertions, because the Commission rejected the ALJ's legal conclusions, there was no 12057 requirement for the Commission to analyze whether the ALJ's legal conclusions should be modified with a legal conclusion the DEF was asserting was as or more reasonable. The Commission did not need to state with particularity its reasons for rejecting or modifying the ALJ's conclusions of law, nor make a finding that its substituted conclusion of law is as or more reasonable than that which was rejected or modified.
Would you agree that the ALJ's conclusions of law either state or assume causation, that the imprudent actions prior to 2012 caused the problems in 2017?
I think the ALJ in his recommended order shows us what he relied on for causation. He had a very specific, detailed section on the findings of fact, and in fact, of course, the conclusions of law contain finding of fact as well. And looking at that, we see what evidence he relied on for causation, which included the Mitsubishi and DEF root cause analyses, especially looking at, I think...
Okay, so when Duke filed its exceptions to the conclusions of law, I read that as taking exception to the finding of causation. And I think the Commission did as well, which is why you use the competent substantial evidence standard of review, correct?
I think the reason that the Commission addressed competent substantial evidence, there were two reasons. One is as part of DEF's argument that there were legal reasons for rejecting the ALJ's conclusion, it brought in as support some of its evidence, okay? And so the Commission, whether or not there had been exceptions filed, it would have been reviewing this recommended order under 12057. And
Okay,
And
so
it would have looked at competent substantial
so
evidence.
in the commission's view, what is the competent substantial evidence that supports the causal finding?
Well, that would be going back to the recommended order, the Mitsubishi and DEF root cause analyses, and those findings of fact in that particular section. And that is possibly Exhibit 115 were the working documents, I think looking specifically at that finding of fact 71. Also, the testimony of Richard Pollack.
Can you tell me exactly where in the order this causal finding is?
I think there's nothing specific that I can remember where they specifically talk about causation, and I
Right,
think
so I mean, the beginning of this thing is like a glorified bench memo. It's party A said this, party B said that, witness C said this. Then we get to the actual thing where the ALJ is actually doing the work, and we get to this inscrutable paragraph 119. I don't see any causal finding there. And then when he closes the loop, he basically just says, we have no idea how we explain what happened between periods 2 and 5, but DEF didn't prove that it wasn't because of period 1. So,
okay.
I mean, what I just want to be clear, what is your best answer on where the causal finding is?
I've got two things I want to address, because I also want to say I think you are correct about burden of proof is very important in this case. Utility always has the burden of proof of showing its entitlement to recovering costs that are then passed on to the consumer. So some of your comments before to the appellant, I think, were correct. They were fair. That there was a lot of conflicting evidence here, and the ALJ had to weigh it, and ultimately the burden of proof was on the utility. Then going back to causation, I think we're looking at Pollack's testimony.
No, I'm from the ALJ. I'm not asking.
Oh.
We can't assume that there was a causal finding and then look for the evidence. I mean, so step one is, where is the causal finding in the order? And only once you've established that do you then get to sort of go through the record and see if there's evidence to support that finding. So where is the finding?
I'm not sure.
So let me ask you.
Agree with that.
Looking at paragraph 119, it reads, it's speculative to state that the original period blades would still be operating today, but had DEF Duke observed the design limits of the 420 megawatts. So that's not the finding. It is not speculative to state that the events of periods 2 through 5 were precipitated by DEF's actions during period 1.
Right.
Isn't that I read that as a finding of causation. Do you? Does the commission view it that way?
No, I agree with that. And I believe that that's what that's where you go back and you look at the recommended order to find where did he get that. And I think he lays it out for us.
No, but I mean, that's
in
to say,
detail.
to say in this vague way that the events of periods 2 through 5 were precipitated. There's a lot that happened in periods 2 through 5. That is not the same thing as saying that. Isn't the question here whether the need to get the replacement power and going offline and everything was caused by the period 1 improvements? I mean, that seems like a much more sort of precise thing than to just say the events were precipitated. I mean, no one disputes that a problem emerged at the end of period 1,
Right.
that all these things were done to try to then fix it.
Right.
It's
And
possible, hold on. It's possible that, right at the beginning, once they did whatever they did at the beginning of period 2, that they had, fixed. I mean, we don't know, and all I'm saying is that this, and I don't know, maybe the ALJ in his mind thought that causation had been proven. I mean, he does repeatedly rely on the burden of proof to me. I just don't know.
I think
And then in this paragraph here, it ends with saying but it is possible to state that events would not have been the same. I mean, what is that?
Right. But I do believe that there is competent substantial evidence that he points to in the recommended order that show that were it not for running the plant over 420 megawatts during period 1, you would not have had this cascading series of events that caused the replacement power costs that have to be passed on. And I'd like to leave a little time for the Office of Public Counsel.
Well, they're actually going to have 10 minutes, so.
Oh, okay, time remaining is just mine, got it. Okay.
So, looking at paragraph 119 in the part that I read, it necessarily has to be given the conclusion that the hearing officer either concluded causation with that somewhat cryptic sentence, or that he concluded that Duke had not met its burden of proof with respect to the issues such that they were not entitled to, I mean, it has to be one or the other, right?
Well, I think it can be both. You know, that there was causation and they hadn't met their burden of proof.
Okay.
No, and I think that's what we find in this case.
So is it your position then that does the proof look sort of holistically at kind of everything that happened between the emergence of the problem and when the ultimate outage happened? Because it's sort of, one thing that's sort of weird about this is that it's been sort of sliced up into all these different periods. But, you know, in some sense, and I don't know if this is a legal question or a factual question, if you look at the way this entire thing evolved over the period of all this time, I mean, no one can dispute that their response to the problem, when the problem was identified in 2012, seems like everything that they did afterward was the essence of prudence, from what I can tell. So are we supposed to just sort of say that essentially there's nothing that they could do after 2012 that would have, I mean, maybe they could have made it worse.
Well, and I think there was some testimony from Richard Pollack that some of the things that the manufacturer had done during that time period, in his opinion, did make it worse. Right,
but that's not DEF's. And no one is attributing any problem to what
Correct.
DEF did after.
Right. The cutting the time period down into different periods was simply a construct that DEF did as part of its root cause analysis, that every time that there was a shutdown, either planned or not planned, that became a period. But that is the only significance it has. It doesn't have a significance as far as the Public Service Commission, in its responsibility under Chapter 366, can only approve as costs to be passed on to the customers prudently incurred costs. And as its responsibility in this case, where it had an ALJ's recommended order to review, it had to follow 12057. And it found that there was no legal basis for overturning the ALJ's decision, and that there was competent substantial evidence supporting the findings of fact. The conclusions of law were supported by findings of fact supported by competent substantial evidence, and it properly followed 120.
Counsel, you're now well over.
Thank you.
May it please the court, my name is Anastasia Perello, and I represent the joint appellee, the customers of Duke Energy Florida, by and through the Florida Office of Public Counsel. I'd like to start by addressing this competent substantial evidence argument that we've been getting into. To your question, Justice Lawson, I agree with Ms. Cowdery. The finding is both that Duke did not meet their burden of proof, which is based on the rejection of their expert's testimony, Jeff Schwartz. Judge Stevenson said that it was unclear how he reached certain conclusions, that his testimony was unpersuasive, and that he was unable to explain away certain criticisms, and that was their burden to meet. However, in paragraph 114, Judge Stevenson also stated that to the contrary, the preponderance of the evidence pointed to Duke's operation of the turbine in period 1 as the most plausible culprit. And all of this evidence is overwhelming. It's Duke's root cause analysis, which is stated in paragraph 71, in which their own experts stated that their actions in period 1 were one of the most significant contributing factors toward blade failure over the history of the turbine. It's also Mitsubishi's root cause analysis, which is restated in paragraph 62 and 71, which is also supports the concept that Duke is at fault for the outage.
If the evidence was so overwhelming, it seems like not too hard to expect an affidavit from the engineer that said, in my professional opinion, what happened in period 1 caused this. That's not really in the record, is it?
In Duke's root cause analysis, their own engineers did explicitly draw that line and say that their actions in period 1 caused the outage in period 5. And to address the comment that Mr. Polich disclaimed that causation, there's a larger context to that cross statement, which the transcripts of that hearing are confidential. However, the context is that he did not conduct his own root cause analysis. He reviewed Duke and Mitsubishi's root cause analyses, and based on those, he found that the damage was likely to have been cumulative, and that but for Duke's actions in period 1, we wouldn't have been here today. There's also abundant evidence.
So the specific language that you're talking about is summarized in paragraphs 62 and 71?
That's Mitsubishi's root cause analysis, yes. There's also abundant evidence about what happened elsewhere, as we discussed, which also supports the finding that Duke was at fault for this outage. And Judge Stevenson stated that it would have been simple prudence for Duke to have consulted Mitsubishi prior to operating the turbine in a manner which Mitsubishi did not anticipate and which Duke knew or should have known was beyond the design point of the turbine. Mitsubishi never wavered from their conclusions in all of the periods that followed period 1. All of this evidence demonstrates that not only was Duke imprudent in period 1, but that this imprudence flowed through and was the consequence of the period 5 outage.
You view the paragraphs 114 and 119 consistent in the sense that paragraph 114 is talking about the period 1 negligence as being the most likely culprit, but then it says in paragraph 119 it's speculative to state that the period blades would still be operating, has the thing about the events happening, but then it says it's not possible to state what would have happened. I mean, it sounds like he's saying two different things in those paragraphs.
Judge Stevenson was stating that it is not possible to predict an alternate future. However, but for Duke's actions, which precipitated the outage, there would not have been periods 2 through 5, and there never would have been the outage in period 5.
What is a court supposed to do when you have kind of an incoherent order like that?
We agree the language is imprecise. However, Duke did not take exception to any of these findings of fact at the commission level, and we would argue that that argument has been waived. Nevertheless, the evidence is overwhelming, even if the statement is slightly unclear.
Well, I don't think the ALJ thought that the evidence was overwhelming, or he wouldn't have emphasized the thing so much at the end. He would have affirmatively talked about the causation going the other way.
Well, causation is an element that is embedded within the burden of proof that the utility must demonstrate that their actions did not cause or significantly contribute to the outage. And again, we have their own engineers saying that they significantly contributed. The second point that I'd like to address briefly is the standard that the commission used in reviewing the exceptions to the conclusions of law. As Ms. Cowdery stated, the statute states that an agency may reject a conclusion of law, and that if they do so, they must state their reasoning with particularity and make a finding that the substituted conclusion was as or more reasonable than those of the administrative law judge. The Commission did not do this, however. They adopted the recommended order without modification and resolutely rejected all of Duke's exceptions. And they did this with a full and complete understanding of their powers under this statute. Nothing demonstrates that better than the statements of Commissioner Fay, an attorney, during the hearing on the exceptions, in which he stated that he did not want the refusal to take the exceptions of Duke to be construed as a misunderstanding of their powers under the statute, stating explicitly, I think it's very clear we have the authority to do that. Duke now attempts to flip this standard on its head and suggest that the Commission was required to accept any conclusion of law that was as or more reasonable. And this is simply not the standard. The Commission went beyond what the statute required and did make a finding that each exception was not as or more reasonable and explain that reasoning, but the statute did not require them to do that. And accordingly, Duke has not demonstrated that the agency's decision is based on any finding of fact that is not supported by competent and substantial evidence, or that the Commission erroneously interpreted a provision of law and therefore has failed to state a basis for remand under 12068. And we would request that this court affirm the Public Service Commission's order.
Few brief points in rebuttal. First, to Justice Kennedy, a more complete answer to your question earlier. The specific portions of the record that demonstrate what happened here, we addressed them at pages 31 to 32 of our brief, and the record citations to the confidential portions there, including Joint Exhibit 82, page 12 of 35. I acknowledge that competent substantial evidence is a high burden in a case like this. So I want to talk about a couple portions of the record where the other side's witness proves our case, in our view, and direct you to those specific parts. The first is one that I discussed earlier. Mr. Polich, the intervener's expert, explicitly disclaimed a causal relationship in his testimony at page 3405 of the record, a causal relationship between period 1 imprudence and the period 5 outage. Mr. Polich admitted that he would be speculating for any other factual basis for the period 5 imprudence. That's at pages 3398 to 3399 of the record. Mr. Polich's theory was that there was imprudence in period 1, and everything after that came after period 1, and therefore was a result of period 1. That's not a causal relationship, and that's not enough. I disagree with my friend on the other side's characterization of the DEF working papers. They were exploring after the fact potential causes of what had happened in period 1. I disagree that they had made a causal conclusion of their own adverse to DEF. And even the PSC's final order here seemed to acknowledge that there was a problem with the way the ALJ approached the prudence analysis. The PSC announced that its final order here was of, quote, limited precedential value, and that it was not adopting any policy that it would be imprudent for a public utility to run a unit above nameplate capacity. That's completely irreconcilable with the ALJ's conclusions, even as to period 1. And Commissioner Pullman's dissenting opinion in the final order, I think, accurately characterizes the nature of what the PSC did with the order that it was presented from the ALJ. In conclusion, my friends on the other side have stated that we're asking this court to reweigh the evidence. We're not doing that. It requires no reweighing of the evidence for this court to observe that one side of the evidentiary scales on causation is entirely empty. There's simply nothing there. So for the reasons stated in our briefs, and unless the court has further questions, we'd ask the court to remand to the PSC either for entry of an order in favor of Duke Energy or for reevaluation of the ALJ's recommended order under the correct legal standards.
So do you read this order as making a causation finding?
Are you referring to the recommended order?
I'm sorry, the recommended order.
I don't. I read the ALJ's order as implying causation through temporal sequence. We identified below and in our briefs the logical fallacy there of saying since it came after, it must have been caused by it. I don't see anything in the ALJ's order that does more than that on causation. There was period 1 imprudence. It's speculative in paragraph 119. It's speculative to say if the blades from period 1 hadn't been damaged, if they'd still be there or not, but things would not have been the same. That's simply not an adequate finding of causation in order to support a finding of imprudence here.
And can we hear your answer as to whether paragraph 114 is a finding of causation?
You sure I'm looking at exactly the paragraph you're referring to there?
Your colleagues on the other side sort of pointed us to, and we discussed, the relationship between paragraphs 114 and 119, which are in some ways in tension, and in other ways you might say 114 comes closer to making a conclusion about causation. And I guess my question is, if 119 doesn't supply that finding of causation, does 114 do it?
I don't think so, Justice Curiel. I think 114 is talking about period 1 issues. It's period 114, and I have the unconfidential copy here, so I want to be careful in the way that I discuss this. The discussions in the first sentence of paragraph 114 and the conditions that it describes there were exclusively present during period 1 and were not present during period 5. So I don't think paragraph 114 or 119 provides that requisite causal link. Thank you very much.
We thank both sides for your arguments in this case today. The court will now